It is a Tuesday afternoon in March, and a woman I'll call Karen is in the produce aisle of her grocery store when her phone rings, and the voice on the other end is a stranger telling her that her mother has just been brought to the emergency room. By the time Karen gets to the hospital, her mother, I'll call her Joan, is already unconscious. A stroke. Massive. The doctors don't know yet whether she'll wake up at all, and if she does, whether she'll be the same person who walked into a coffee shop that morning. Karen is standing in a hallway in the clothes she threw on, trying to understand what they're telling her. And here is the moment this video is about. Because in the next 6 months, Karen is going to discover, one at a time, in the worst possible way, that her family is missing 4 specific legal documents. Each one is missing at a different stage of the worst crisis her family will ever face. Each one would have taken her mother about an hour to sign on any ordinary afternoon for somewhere between $300 and $1,500. And the absence of each one is about to cost the family thousands of dollars, weeks of delay, and 3 months of a sibling fight that will not fully heal for years. If you are watching this video, you almost certainly have 1 or 2 of these 4 documents already. Almost no family has all 4. Most have none. And the absence is invisible until the day it isn't. By the end of the next 20 minutes, you'll know exactly what each of the 4 documents is. In plain English, the precise moment in a family crisis when its absence becomes catastrophic, and the order in which to put them in place for your own parents, not theoretically. This week, here is the honesty I always owe you, because trust is the only thing that matters on a channel like this. Karen and Joan are composites, names changed, details combined from many real families I've drawn from in researching this video. The medical crisis is generic. The legal mechanisms are exact. I am not your attorney. The names of these documents vary slightly from state to state, and the formal requirements vary too. California has its own statutory forms, Florida has its own quirks, New York has different rules in places. So treat what you're about to hear as the universal map. The person who fills in the forms for your state correctly, for somewhere between $300 and $3,000, is a certified elder law attorney. We'll get to when in this story. Okay, let's stand in that hospital hallway with Karen and watch what goes wrong. The first crisis hits within the first hour. The neurologist comes out of Joan's room and tells Karen that they need to make some decisions, quickly. Should they perform a particular procedure that has real risks but might save more brain function? Should they go aggressive or conservative? He needs an answer in the next 30 minutes, and he needs to know who to ask. And he says the sentence that decides the next 6 months. Who is your mother's healthcare agent? Karen says, I'm her daughter. I can decide. The neurologist kindly says, that's not how it works. This is the first document. It's called, depending on your state, a healthcare power of attorney, a healthcare proxy, a medical power of attorney, or a healthcare agent designation. The terms mean the same thing. It is a 1-page document, signed in advance by your parent, that names the specific person who is legally authorized to make medical decisions for them if they cannot make those decisions for themselves. Without it, your hospital does not know who in the family to listen to. And here is the part that catches almost everyone by surprise, the part I really need you to hear. Being a spouse or an adult child does not automatically give you that authority. In a lot of states, there's a default order, spouse, then adult children, then siblings, but the default has gaps, and the gaps are exactly where families fight. If 3 adult children disagree about what mom would want, the hospital often has nobody clearly in charge to break the tie. The result is delay. Sometimes serious delay. Sometimes the wrong decision, made by committee, in a hallway. A healthcare proxy is the document that ends that fight before it starts. It says, this one specific person speaks for me when I can't. There's a piece of this document, by the way, that's almost as important and gets forgotten constantly. It's called a HIPAA authorization. HIPAA is the federal medical privacy law, and here's what it does in a crisis. Without an authorization, the hospital is not allowed to share your mother's medical information with anyone she hasn't explicitly approved. Not her diagnosis, not her prognosis, not whether she's even at the hospital in some cases. Adult children calling from out of state can be stonewalled, completely legally, by an information desk that is just following the law. The HIPAA authorization fixes that. In most well-drafted healthcare proxies, it's baked right in, but you have to check. If your parent has a healthcare proxy that doesn't include HIPAA language, the hospital can talk to the agent, but not to anyone else in the family. So when you do this with your parent, you do them together, not separately. In Karen's case, there is no proxy, and there is no HIPAA. The neurologist makes the call with Karen, against the protests of her brother who's just landed from out of state, and feels like the decision is being made behind his back. The procedure goes okay. The family does not. The second crisis hits about 36 hours later, and it's the document that pairs with the first one. And the difference between the two is the difference that almost nobody understands. Joan is alive but in a coma. The medical team needs to know what to do next, and one of the doctors gently asks Karen and her brother whether they know what their mother would have wanted in this situation. Did she want to be kept on life support indefinitely? Did she want a feeding tube? Were there things she had said, written down anywhere, that could tell them anything about her wishes? Karen and her brother look at each other and realize they have no idea. Not what she would want. Not what she once said. Their mother had been healthy. They never talked about this. So the two of them sit down in a small conference room and try to guess. And predictably, heartbreakingly, they don't agree. This is the second document. It's called a living will in most states, an advance healthcare directive in others, or sometimes just an advance directive. It is not the same thing as a healthcare proxy, and confusing them is the single most common mistake in this whole subject. So here's the distinction in one sentence. The healthcare proxy names who decides. The living will says what they decide. A living will is your parents' own written instructions, in their own voice, for exactly the situation Karen is in right now. It says, if I am terminally ill, do this. If I am permanently unconscious, do that. If there is no reasonable chance I will recover, here are my wishes about life support, and feeding tubes, and CPR, and pain management. It is written calmly, in advance, on a normal afternoon, when your parent is clear and unrushed and has had time to think about what matters to them, and it ends. And this is the part that saves families, the conversation Karen and her brother are about to spend the next 2 weeks having. Because their mother is no longer there to break the tie, and they each love her in slightly different ways, and they each believe in their hearts that they know what she would have wanted, and they are about to discover that they know completely different things. A living will is not a death planning document. It is a sibling saving document. Your parent makes the call once, in their own words, and their kids never have to fight about it. That is what it is for. The third crisis hits in week 4. Joan is still in the hospital. She is stable but completely unresponsive. The bills are piling up. The mortgage on her house is due. Her car insurance lapses. There's a property tax bill on the dining room table. Karen drives over to the house to start handling things and discovers that she cannot. Joan's bank account is in Joan's name alone. The credit cards are in her name. The mortgage is in her name. Karen has Joan's wallet, her checkbook, and a working knowledge of Joan's PIN, and none of that is the same thing as legal authority. When Karen calls the bank to explain that her mother is in a coma and can someone please pay her mortgage so the house doesn't go into default, the bank politely declines. And here we have the third document, the durable financial power of attorney. We made a whole video about this one, but the headline is this. It's the document that names someone, an agent, usually an adult child, who is legally authorized to handle your parents' financial life if they can't handle it themselves, paying bills, managing accounts, filing taxes, selling property. Without it, Karen's options are exactly 2. She can pay her mother's bills out of her own pocket for the duration of the crisis, which can run into the tens of thousands of dollars and may never be reimbursed. Or she can go to court, hire a lawyer, file a guardianship petition, get an evaluation, attend a hearing, and ask a judge to give her the authority that one signed document would have given her in 5 minutes. The word that matters on this one, and I cannot say it enough, is durable. A regular financial power of attorney quits working the moment the person who signed it becomes incapacitated, which is the exact moment you need it. A durable one survives incapacity. Without that one word in the document, it's not the document we just described. So if your parent already has a financial power of attorney signed somewhere, that's the first thing to check. I want to stop here for a moment because I want to talk to one specific person watching. If your parent is healthy right now, still arguing with you about whether they should drive at night, still cooking on weekends, still bossing you around, I know this video is uncomfortable to watch because it asks you to imagine the worst week of your future life, in detail, in advance. But here is what I want you to see. Karen, in that hospital hallway, would have given anything for the version of herself I'm talking to right now, the version of her that still had time. Every single one of the 4 documents I am describing is something her mother could have signed, in calm, on any ordinary Sunday, with a cup of coffee in her hand, in less than 2 hours total. The version of Karen with the documents and the version of Karen without them are not slightly different. They are different people, living different 6-month nightmares. The difference between them is one Sunday. That's what I want you to take from this video. You have today what Karen would have given everything for, and the cost of using it is one Sunday afternoon. Okay, the 4th document. 3 months into the coma, Joan passes away. The family grieves, and about a week later, sitting at her mother's kitchen table, Karen realizes she does not know whether her mother had a will. She finds a small fire safe. She digs through the desk. She calls the family attorney her parents had used decades ago, who is retired. Nothing. There is no will. This is the 4th document, and it's the one most people actually think of first when they hear the words estate planning, the last will and testament. It is the document that, after your parent dies, tells the world who gets what, who is in charge of distributing it. The person called an executor, and if your parent is raising minor children or grandchildren, who is their legal guardian. That last one matters, and almost nobody knows it. A trust cannot name a guardian for minor children, only a will can. So even families with a fancy trust still need a will for that reason alone, if there are kids in the picture. What happens when there is no will is something families discover, like everything else in this story, at exactly the wrong moment. The estate enters what's called intestate succession. The state in which your parent lived has a pre-written script for what happens to the money of someone who dies without a will, and that script does not know your family. It doesn't know that your sister did everything during the crisis. It doesn't know that one sibling has been estranged for 15 years. It doesn't know that mom wanted the wedding ring to go to her granddaughter. The state's formula divides things according to a flat list of relatives. And in the absence of clear documentation, the resulting fights inside families between siblings who all loved the same mom in different ways are the saddest part of this entire video. Without a will, you don't get to grieve. You get to negotiate. A simple, valid, current will heads off almost all of it. And if your parent already has one, the question to gently ask is when it was last updated. Because a will from 1994, written when the kids were toddlers, naming a guardian who has since died, and an executor your parent hasn't spoken to in 15 years, is sometimes worse than no will at all. So those are the 4. The healthcare proxy, the living will, the durable financial power of attorney, and the will. 4 documents, 4 different moments of a possible crisis, 4 different ways your parent stays in control of what happens to them and what they leave behind. Without them, the state, the hospital, and a courthouse take over. With them, your family stays in charge. Now here's the practical part. How do you actually get these in place? It's simpler than the legal language makes it sound. First, today, find out what your parents already have. They may have a will from years ago. They may have 1 or 2 of the others. Many families have a will and nothing else, which protects them after death but leaves them completely exposed during a long illness. So step 1 is just inventory. What's there? Where it is. When it was last updated. Second, for documents they don't have, or that are old, the right professional is a certified elder law attorney or estate planning attorney. For a straightforward family, no business, no blended family, modest assets. A basic set of these 4 documents typically runs somewhere between $300 and $1,500. Some states offer free statutory forms for the medical documents that are perfectly valid on their own. For families with more complexity, significant assets, real estate in multiple states, blended families, minor children, the costs are higher and the attorney's help is genuinely necessary. Third, after these are signed, do the thing nobody tells you to do. Tell at least 2 people in the family where the original documents are. A safe deposit box at a bank is actually a poor place to store these, because no one can get into it without, yes, exactly the documents that are sitting inside it. Better is a fireproof home safe whose location and combination are known to the named agents. Give copies of the medical documents directly to your parents' primary care doctor and to the hospital they would most likely be taken to. The healthcare proxy is useless in a drawer if no one can find it at 2 in the morning. Fourth, review every 3 to 5 years and after any major life event. A marriage, a divorce, a death of a named agent, a move to a new state, because documents valid in one state may not work the same way in another. And fifth, the one nobody plans for, but should. Have a calm, 10-minute conversation with your parent about who gets called first in a crisis. Not who decides that's the document, who gets the phone call. Because in a real emergency, the order in which the family finds out about what's happening is often the start of every fight that follows. Get ahead of it. Here's the reframe to carry out of all this. These 4 documents are not about death. 3 of the 4, the healthcare proxy, the living will, and the financial power of attorney, only ever come into play while your parent is alive. They are about staying in control during the part of life that's hardest to control. The will, the 4th one, is the only one that's about after. So when you bring this up with your parents, please don't frame it as estate planning or as a death conversation. Frame it as what it actually is, making sure that if anything ever happens, the family knows what mom wants, and the hospital knows who to call, and nobody has to spend the worst week of their life standing in a hallway trying to guess. So if you remember one thing from everything we've covered, let it be this. 4 documents, 1 Sunday afternoon, somewhere between $300 and $1,500 for a normal family. That is the entire difference between Karen's 6-month nightmare and a family that gets to grieve in peace. The cost of the prevention is laughably small compared to the cost of going without it. The only thing standing between most families and the protection is that they've never been told exactly what to get. You've been told now. If your family has been through a version of Karen's 6 months, a hospital hallway, a missing document, a fight that didn't have to happen, please tell me about it in the comments. Because there is somebody scrolling tonight whose parents are healthy and clear-headed right now and who has been putting off this exact errand for years. Your story is the thing that gets them to put it on the calendar this weekend. And here's where we go next. Now that you know what to put in place, the next question every family runs into is the practical one. How much is all of this actually going to cost? Care, facilities, the works, if my parent does need help? Most families have no idea what the real numbers look like, and the gap between what people assume and what care actually costs in this country is the single biggest financial shock most families ever receive. There's one number in particular that quietly bankrupts families who never saw it coming. That's the next video. If you've ever wondered whether your parents have enough or whether you'll have to step in, watch it next while the documents conversation is still fresh.